Welcome into this week's episode of Crime Watch, where we discuss crimes and cases in Southwest Virginia and Northeast Tennessee. Thanks for joining us for this week's episode. I'm your host, Ansley Daniel. I've got a special guest in the Digital Center with me today. I've got Dr. Ken Lang from Milligan University. Thank you so much for joining us for this episode today.
Yeah, absolutely. Thank you for having me, Ansley.
Well, I know that you are super busy, so we appreciate you for taking the time to do this, but I want to go ahead and delve into your background before we get too deep into the cases that we're talking about, because I want folks to know a little bit about you and why you are so qualified to speak about some of these things.
Sure. So I am a 25-year law enforcement veteran. I've retired from the Baltimore County Police Department. 15 of those years were investigating rapes, robberies, and murders. And I also served as an adjunct instructor with my agency, and that led to me discovering my talent in teaching. And so I went back to school, pursued my bachelor's, my master's, and my PhD in criminal justice, and finished that. And now I'm here as an associate professor at Milligan University teaching future criminal justice professionals about this profession.
Well, I know that you have worked so many different cases to get to this point, so you've seen so many different things. But I want to talk to you about 3 different cases that we've been following here at News Channel 11. And they all kind of came, to a head, for lack of a better word, at a perfect time in court Friday in Washington County. It was a very busy day there in Washington County, Tennessee last Friday. So I want to pick your brain about a couple of major cases, like I said, that we've been following. That first one is Christian Zarate. Now, this is the Johnson City teenager who was tried as an adult and faced a plethora of charges related to allegations that he recorded videos of his juvenile classmates and used AI to generate pornographic images of those friends, co-workers, things of that nature. And the Johnson City Police Department reported that he also took photos from their social media pages to place into the AI generator. Now, investigators reported finding more than 50 images in his possession that would be considered child pornography, including 28 different AI-generated sexually explicit photos of his female classmates. Now, he was 17 when he was charged. He has since turned 18, but this was him in court on Friday. As you can tell there, he was in Washington County, Tennessee court there. He did accept a plea deal. Zarate pleaded guilty to 13 of the dozens of charges that he faced, including especially aggravated sexual exploitation of a minor, aggravated sexual exploitation of a minor greater than 50 images, and 10 counts of unlawful photography for sexual arousal and gratification. So a lot of different charges that he was faced with there, and I want to play a quick little clip from court before I start asking you questions about his plea deal.
Court sentences you to 3 years in the Department of Corrections as a standard offender for classification. In each count 1, 2, and 3, you are, however, subject to 100% service of that sentence if you violate the conditions of probation, which will be agreed to. Counts 1 and 2 are concurrent with each other. Count 3 is consecutive to counts 1 and 2. That gives you an effective 6-year sentence on these 3 counts. You understand that?
Yes, Your Honor.
And so we know that this is all happening in the Johnson City area, and as part of his plea, Zarate is set to be registered as a sex offender for life. He's going to serve 6 years of probation along with a 2-year term to be served concurrently on probation. Now, Dr. Lang, I want to ask you a couple questions about this plea deal. First off, is this enough for all of the different things that he was charged with?
It's typical that prosecutors will charge people with all of the counts that they feel confident that they can prove them on. And this lends towards them being able to put a hammer over the defendant's head for the plea bargaining process. And so here in this case, we had the 28 counts of the sexual exploitation of the performance of production, the 2 counts of the exploitation of the minor and the images and all of that. So the prosecutors felt confident that they could prove each of those charges, but then what happens is then the prosecutor will sit down and say, what does this look like on the matrix of a for other individuals in a similar situation? So he was 17 and now he's 18 at the time. He's still he's in between that juvenile court and that adult court situation, and so the courts recognize this, and the courts also recognize that because of his youth, that he is not fully developed yet. Right, he has not fully matured to an adult status. So. Is this right? I think, for if this is his first time offense and he's not done this before, and the mental evaluation shows that he has no real addiction to child pornography, then perhaps it is. But time will tell.
And with this, another stipulation of his plea agreement is that he's prohibited from using any social media or AI. Also ordered to have no contact with the victims in the case. That's pretty standard. But how are they going to monitor his AI and social media use? Is that something that you typically see in cases like this? And how are they going to make sure that he's actually, upholding to that?
Yeah, so that's a great question, and a lot of people don't realize that what will happen in his case now that he has pled guilty and agreed to the probation. His case will go to probation. He will be assigned to a probation agent, and that agent does actually have some technological means for monitoring through the URL of the home. So he'll have to register his devices and all of that. He'll have to identify his logins and his email address and that type of information for the agent to continue to monitor. But then in addition to that, throughout this time period, the agent is going to also conduct an investigation. So agents have the ability to do unannounced checks, unannounced searches, and in these cases now they can even subpoena records without the defendant knowing that those records have been subpoenaed, looking for any information. And then if something comes across that violates that, then the probation agent is going to do what they do and then violate their probation and move on with that.
Well, I also want to ask you another question about the victims in this case. Do they get a say in this punishment? How exactly does that work in this? Do they, get to give some input on what they think is fair when you come to a plea agreement like this?
Yeah, that really this depends on the prosecutor themselves. So some prosecutors are really good about going to defendants. And in my time when I was serving as a sex crimes detective, we often did that. We would sit down with the victims and talk about this is what we have, this is what we can prove, but this is what we're thinking about offering for a plea agreement. And oftentimes, at least in those cases, the victim didn't want to take the stand and have to testify in a public arena about the events that had transpired. And so I would liken that to these juvenile victims, that very well may have been the case for them. But then at the same time, you don't want a sex offender going out and recidivating and then causing others to become victims.
Well, you kind of just led into my next question. This case did receive a good bit of attention from us. We were tipped off on it. We were able to go to the first court hearing, I think a few months ago at this point, where he was in juvenile court. I was there for that. But I think the big thing here is that this technology is so new with AI, and it's almost setting a precedent, for lack of a better word. What kind of precedent did the judge set with this punishment? And, does that, you think, maybe deter people from doing this crime again? Or do you think it's not enough, especially as we're on the front end of all of this?
So there's two specific ways that we want to approach deterrence. One, we want to deter the actual offender themselves. We want them not committing the offense again. We don't want them recidivating and then becoming a menace in our societies, right? And then there's the general deterrence, that of deterring the public. And so in this case, again, we're looking at a young offender, and so that carries some weight to it with regards to how the judge proceeded in this case. Given that they're young, I imagine no criminal record, prior record at all. And that weighs heavily, too, in the decision, particularly with deciding on how to form that plea bargain. But I mean, the other thing that we also need to keep in mind too, and a lot of people don't realize, is that for those who are put on probation, it's only about 1/3 that violate that probation and end up having to carry out the sentence that they've been given in court. And so, if he doesn't violate that probation, then he should be well on his way to doing well. And then the question is will he recidivate at all? And so with child pornographers, that typically falls within about a 3 to 17% average for recidivating.
Well, I do want to ask you one more question before we take a quick break and move on to another case. With this, we know again that this is the front end, but he also is going to have to register as a sex offender for the rest of his life. He just turned 18. What does that process look like? And, like you said, he might not ever commit this crime or another crime again, but this is still something that's going to follow him for the rest of his life, right?
Yeah, absolutely. And so he'll have to report to the sheriff's office, and then there's usually a packet that they're given, and they'll need to fill out those packets, turn them in, and then they're fingerprinted, photographed with that registry, and then that information is disseminated to entities throughout the nation. There are a host of websites that monitor where sex offenders are residing. And that registration is also going to limit him in his capacity, for instance, where he can live. He can't move within a certain distance of public schools, and so on and so forth. And so that will follow him. But then probably the biggest impact that's going to have is if he's applying for jobs and it requires a background check, that information is going to come up. So unless the employer is asking specifically for this information on an application, they won't know. And that could be problematic. Employers don't want to incur the liability of potential risks. And so who's to say he wouldn't do this with employees, whether they're adults or the juveniles. And that can become a concern. And so that weight of that will carry on his shoulders the rest of his life.
Well, and like you said, this has already been done once with his coworkers. So, I mean, you hope that he does not reoffend, and this is enough to keep him out of that arena. But I guess time will just be what tells in this case. But I do think it's very important to note that we're on the front end of this AI and image generating type situation. So I do think it kind of sets a precedent for a lot of different things. I know when we first heard of the case, we were like, this is going to, be a big deal because we knew that something like this had not really been heard of before now, especially with all the technology coming out. Well, we're going to take a quick break here. Dr. Lang, thanks for joining me. And when we come back, we're going to talk about another court case that was in Washington County, Tennessee court on Friday. They had a very busy day there, but we're going to break it all down for you and give you the details that you need to know. Stick with us because we'll be right back. Thanks for joining us and for sticking with us for this week's episode of Crime Watch, where we talk about local cases, cold cases, anything related to crime happening here in our area. And we also delve into a little bit of law, too. Today, I am joined by Dr. Ken Lang from Milligan University. Thanks so much for being here and for breaking down some of these big cases happening in our region right now.
Absolutely, Ansley.
Yes, well, I want to go ahead and get into the next one that we want to take a look at. The man accused in a fatal downtown Johnson City crash earlier this year was also in that Washington County, Tennessee courtroom Friday. Stephen Katsanis is facing multiple charges, including 3 counts of vehicular assault, vehicular homicide, driving under the influence, and leaving the scene with property damage. He's accused of driving into a parking lot in downtown Johnson City, which left 1 person dead and 3 others hurt back in May. He pleaded not guilty as soon as it happened, and this past week in court, he did ask to represent himself. And here is what the judge had to say.
You understand this is not a simple case, and you should not represent yourself on this kind of case. So do you want to fill out paperwork for counsel? The state is not going to make you any kind of plea offer today.
Yes, ma'am.
Fill out the paperwork, I'll bring it back over.
So, as we can tell, that was Judge Rice explaining that he did not need to represent himself in a case like this, giving him some advice, I guess, for lack of a better word there. But, Dr. Lang, why do people try to represent themselves in cases like this?
Often in these cases, the people just think of themselves in such a way that they feel that criminal justice is common sense, that it's pretty straightforward. I would imagine specifically in this case, he may be thinking that being intoxicated is a defense, and that is not the case. And they'll just often want to tell their story in order to feel guilt, compassion from the jurors, hopefully to sway them in that direction, and then obtain that not guilty plea.
And I know that judges, typically don't insert themselves in cases, things of that nature, but she seemed pretty firm on saying, hey, you do not need to do this. Why do you think she was so adamant about that as the judge?
In my experience, all judges have been rather adamant about this. I mean, think about the qualifications that are needed for an attorney in order to practice law. You have to obtain a Juris Doctorate. That's a 3-year master's level program. It's a doctorate program in law. You need to be able to navigate the law library, which is filled with tons of resources and prior case law, and understand how that case law can be researched and then implemented into the specific facts of your case. And then once you've graduated from law school, then you need to be able to pass the proficiency test in order to pass the bar exam, in order to even practice and obtain your license to work in particular jurisdictions. And so there is much to representing yourself, or having someone represent you would be better.
And I know that this case is still on the front end. However, we are talking about obviously the DUI charge, but vehicular homicide and vehicular assault, because of all of the injuries. I know when this case came about a couple months ago when it all happened, we were all kind of shocked because it was gruesome. It was a lot, and those victims have already started taking the stand in this in some of their proceedings. So with that, do you think that, having an attorney is probably in his best interest, because people are going to be hearing from victims, they're going to be hearing from the family of the one victim that died, and so could that, maybe be a wise choice for him?
Yes, absolutely. Having an attorney, again, there's a ton of benefits. But then here in Tennessee also, I'm not sure how many viewers are aware of this, but Tennessee courts have what's called elbow attorneys. So in these situations, and I've had the opportunity to witness this before here in Tennessee, where a judge will appoint a licensed attorney who is in the court to sit at the elbow of the defendant. Now, it's a resource, and the defendant will need to ask and interact with that attorney in order to get the legal advice. So this elbow attorney would be able to lean in and say, you should ask the questions this way, or you should be asking these questions, or you don't want to ask these particular questions, and explain why. Now, the ultimate decision in how that defense goes will remain with the defendant, but they will have the luxury of having that legal advisor sitting by their side as a valuable resource.
Yes, I've seen that play out in a federal courtroom before, and like you said, it is a resource that they can go to, but not necessarily something that they are required to take their advice on. Well, do you have any final thoughts on this case before we take another quick break and talk about our final case in this week's episode of Crime Watch?
Now, what a horrendous case, and this was captured on the flock cameras, and I think in this day and age, a lot of this is going to speak for itself.
Yes, like you mentioned, so many different pieces of technology and things of that nature that are, helping law enforcement in some ways. I know that there are some pushback right now on the flock cameras, but in this case, it could be something beneficial for them. Well, we are going to take one more quick break before we come back and talk about the case of Keith Irvin, the Washington County, Tennessee school member who is facing one charge of assault. So stick with us because we'll be right back on this week's episode of Crime Watch. Well, thanks for sticking with us for this week's edition of Crime Watch, where we are discussing a couple of major cases that we've been following along in Washington County, Tennessee. I'm joined today by Dr. Ken Lang from Milligan University, helping me to break it all down and wrap our brains around all the things that happened. It was a pretty busy day in that courtroom, wasn't it?
Yeah, absolutely.
Yeah, it was almost a marathon for our team and for those that were there. But we want to get into this last case. We are going to talk about Keith Irvin here. This is the Washington County, Tennessee school board member who was set to appear in court on Friday, but he waived his right and he pled not guilty to one charge of assault. Now, this stems from an incident at a school board meeting earlier this year. I want to play you the clip of what happened.
God, you're hot. You know that? Hey, where do you go to school at?
I go Crockett.
All right.
And again, this happened at a school board meeting earlier this year where he came under significant scrutiny following this incident. He was censured by the school board, the county commission issued a vote of no confidence in him, and students at David Crockett High School even sent a letter to the school board asking that Irvin not attend any of their final events for the school year. He was charged with assault as a Class B misdemeanor back in May. So now I want to go ahead and bring in Dr. Ken Lang. So Dr. Lang, first tell me, after seeing that video, he did touch the student, but how exactly does this incident fall into the definition of assault as we know it?
So the Tennessee Code under 3913-101 identifies that physical contact. It doesn't have to cause injury, but if it's offensive or provocative. And so this contact, in conjunction with the statements that he made during this meeting, could very well be considered offensive or provocative. And so under the definition, it indicates that. And the law even goes so far as to just to give this vagueness and broadness, and it leaves it to the victim to explain or express how they interpreted what they went through and what they were feeling at the time to bring about that offensiveness or the provocativeness that it elicited. And so in generally speaking, with assaults, law enforcement has been trained that the touch, no matter how much the slightest it is, if it is unwanted by the victim, it's an assault. And so, we look at this video. It's obscured because we're protecting the juvenile's identity, right? But in court, the jurors or the judge, whoever is the finder of fact, will be able to see that. And I'm curious to see, how did he touch her? Is he caressing her? Is he rubbing her back? And that would even give us more information towards that definition of offensive and provocative.
And with him being an elected official at the time that this happened, could he face any other charges in addition to what he is already facing?
Officials, elected, those who take a sworn oath, such as law enforcement officers, we have always been faced with the possibility of malfeasance of office as a possible charge as well. There are additional crimes that a prosecutor could bring in such cases against those who are in these positions of authority. We need to hold people accountable in their actions and their conduct when working with that authority. And in this case, that authority may lend towards part of that offensiveness in this assault case.
And we also know that he waived his right to appear. I'm going to just show some video of court on Friday. That's his attorney, Gene Scott, where he pleaded not guilty to this charge. However, he chose to not appear in court, just sent his attorney. I know that that's something that's pretty common. I've worked with Gene on a couple of different cases as well. That's something that he has done a couple of times recently in some cases that he's representing. But would a case like this go to trial? I know that, with him being such a well-known figure in the community, that this probably was in his best interest to not go on Friday as well.
Yeah, so this is a first appearance. The presence of the defendant is not necessary. Particularly in this instance, the attorney can stand in and represent the client and go forward. And then what will happen is then the prosecutor is going to sit down and look at the case and then decide on a plea offer. And then they'll have those conversations with that attorney, and then So while he's pled not guilty at this point, which is legally the smart thing to do because that leaves the doors open for all the legal avenues that are available to a client. The moment he pleads not guilty, those doors begin to shut, because if the court goes through and qualifies that guilty plea, and then it binds to that client, and then once that happens, then there's only a few avenues that are available to reverse that.
Yes, and so, like you said, this has a long way to go, but I do think it's important to note that Friday was the day after the election. He lost his election bid the night before to the Board of Education, and so, again, this was the following morning, probably found out around, 10 or 11 o'clock that night that he didn't win the election, and then, of course, was set to appear in court Friday morning, and I think that has another factor as to why maybe he chose not to appear, just simply because, he was a major topic throughout the election cycle. He had an opponent, that opponent won. And so I think that might have also played a factor into that decision. But, again, this case has gotten a lot of attention. It's gotten national attention. So I think that could also be a reason as to why, he picked Gene Scott to represent him, but also, choosing to go about this in a very strategic way. But I know that this could also, also have some civil situations that happen with it. Let's talk about that quickly before we wrap up this segment.
Yeah, so typically what happens in the criminal justice realm is that those people who are found guilty can be held subject to civil liability as well, depending on the crime that they're charged with and what they're found guilty of. And so typically what happens is that if there is going to be civil proceedings, they won't evolve or make themselves known until after a verdict has been reached in the criminal trial, because once that verdict has been reached, it makes the civil proceedings all that much easier. And so most attorneys will recommend to their clients that we hold off on any civil proceedings. But here in the state of Tennessee, there are specific codes concerning civil assault and civil battery, and they hinge on the emotional distress that it may have caused, the civil rights violations, any defamation or ongoing harassment that may have been involved in that. And so those proceedings can come up in the future. I would say that if this criminal case reaches a point where a verdict of guilty is rendered, it is possible that we will see the family then file suit for civil proceedings.
All right. Well, Dr. Lang, thank you so much for taking the time to come in and break down these cases with us. The next hearing for Keith Irvin is set for November 2nd. And of course, we will continue to follow all of these to their extent. But Dr. Lang, thank you so much for taking the time to join us for this week's episode of Crime Watch. We appreciate you and all the expertise and insight that you provide to us.
Thank you, Ansley. It's been a pleasure.
Yes. Well, again, that is all we have for this week's episode of Crime Watch. Thank you so much for joining us and for sticking with us. Can't wait to see you next week as we discuss even more topics right here in Northeast Tennessee and Southwest Virginia. We'll see you next time.